We shall never, never, never surrender. Never, never, never surrender. Never, never, never surrender. Never surrender. Never, never, never surrender. Never, never, never surrender.
C, the command of the Constitution, says shall, and therefore does away with the ordinary bail application, which is made that allows for a discretion. So it is a constitutional command. What the court ought to satisfy itself is that the offense is triable only by the High Court. And that the person who is the applicant has been on remand for more than 180 days before commitment. So I join issue with my senior colleague, Mr. Karua, that the committee per se does not take back time to nullify the 180 days. The 180 days are a constant. Two, Your Worship, is that the 180 days referred to in the constitutional command do not start to run from the date when the applicant is arraigned in the court before which the application is made. I'm saying that the 180 days, upon which bail becomes mandatory, are not counted from the date when the applicant or the accused person was arraigned before court, before which the application is made. And mindful of the decision of the Supreme Court directed a transfer of the files. What I'm trying to say, Your Worship, is that the process from the court-martial to this court is continuous. There is no break so that the proceedings before the Court of Appeal, the court-martial, are not taken into consideration. So when we stick to the 180 days, Your Worship, the court must take into consideration the date of remand by the General Court Martial, because it is also a court under the Constitution. So that article, Your Worship, again for emphasis, says in case a person has been remanded in custody. It doesn't say, it envisages that a remand can be made by any court of law or any court as established by law of which the General Court Martial is just one of them. So the argument that may arise from the prosecution that the proceedings in or before this court did not commence or commence this year, and therefore they are not 180 days, does not hold. Court takes into consideration the time when the remand started to run, count the 180 days. And Your Worship, there is a view that perhaps in matters or offenses tried only by the High Court, the Magistrates Court should not grant bail because the matter is tried by the High Court only. Your Worship, in the current constitutional dispensation, the Magistrates Court is empowered to grant mandatory bail. Your Worship, it's a common fact that the Constitution applicable in Uganda was promulgated in 1995, so that decisions made thereafter bear in mind the constitutional order of the day. Your Worship, in Uganda versus Tesimana Rosemary, the Honorable Mr. Justice FMS Egonantende, as he then was, Tesimana Rosemary, is criminal revision cause number MSK hyphen 00 hyphen CR hyphen CV hyphen 0013 of 1999. I cite it because it is the current dispensation. Because in that case again, Your Worship, the magistrate had declined to exercise powers and sent the file up for revision on the ground that the matter was tried by the High Court. Your Worship, I beg to read, and I'll avail a copy, what the Honorable Justice Egonantende said. My Lord, it is Your Worship, it's the highlight at page 13. So before I take leave of this case, I must say that courts cannot escape the blame for this unhappy set of affairs in the criminal justice system, which has no remorse for caging up people in penal institutions for unjustifiable periods of time. It would appear that magistrates' courts to which accused persons are first produced before committal regard themselves as no more than, should not regard themselves as no more than assembly line of conveyor belts run by the prosecution. For years on end, the court is content to record endlessly adjournments, etc. But the point that my Lord, the judge said at paragraph 39, that even though a magistrate's court has the jurisdiction to try capital offences, accused persons such charges are brought before it to ensure that, among other things, the accused rights are protected. The courts must be vigilant in doing so by consistently requiring the prosecution to provide information regarding the investigation. What we are pointing out here is that the constitutional command says that once the accused person is emphasizing their rights, once the matter is before it, even for capital offences, this court cannot feign not to have jurisdiction on ground that the offence is of a capital nature. In Article 23C, therefore, the accused persons contend that they have been on remand by order of the court so established under the Constitution, the GCM, for a period exceeding 180 days. If I count well, Your Worship, today there should be 196 or thereabout. And that the matter which is before this court now is because the accused persons are exercising their right to mandatory bail as commanded by the Constitution. The onus of the court is, upon being satisfied that the 180 days on remand have elapsed, is, as the provision says, that person shall be released on bail on such conditions that the court considers. Your Worship, we are mindful of the fact, and we were told before, that there are practice directions regarding bail applications, or bail for that matter, in magistrates' courts, which were handed down by the principal judge in regard to capital offences. Your Worship, those practice directions are not in respect to mandatory bail. They are in respect to what I would say, for want of another description, ordinary bail, or bail in ordinary circumstances. In this case, the reason why the Constitution makes a specific command is that the state is expected to have wound up its investigations and made a committal in 180 days. In any event, Your Worship, the practice directions of the principal judge and even Chief Justice cannot override the express provisions of the Constitution. We just wish to remind the court, and we are aware that the court is already aware, that the Constitution is the supreme law of the land. Your Worship, Article 2 of the Constitution is clear. Under the subheading Supremacy of the Constitution, states that the Constitution is the supreme law of Uganda and shall have binding force on all authorities and persons throughout Uganda. So, Your Worship, that means that the Constitution and its provisions have binding force on this court, on the persons of the Chief Justice and the Principal Judge, ordinarily in their individual capacity, and also in their official capacity, exercising their powers as the Chief Justice and the Principal Judge, respectively. So much so that the practice directions they pass must be brought in conformity with the Constitution. They cannot surpass or override the power in Article 23, which my land colleague, Mr. Rukwabo, area senior counsel, referred to. We reiterate the prayer that 180 days have elapsed, and as the defense we shall happily receive the conditions for the mandatory bail because it is a command that it must be granted.
One of my colleagues will submit an authority. After me, the senior counsel was our presentation in this application. But I want to start with or just emphasize the practical matters. The date of remand and custody was 20th November 2024 by General Court Martial, criminal case number UPDF stroke GCM stroke 040 stroke 2024. The state is aware of this fact because they have said so in an affidavit before this honorable court. The state, through its detective IP or Benedict, they acknowledge that the respondents, namely the accused, were previously charged for the General Court Martial at Machinde. The application was filed on 5th March 2025, and it is the application for accessing the court records. Yes, the telephone particulars, which your honor is on this honorable court's record.
I think, Your Worship, maybe just to interject a bit, allow me some.
I am not saying the word and you're panicking.
Just speak.
Yes, you can't stop me before I say the thing. Relax.
I hope you don't commit any other controversy.
No, it's fine.
So what I'm saying is that the document which Malandi brother is referring to has not been adjudicated upon, and therefore it cannot form part of the record. We cannot preempt a document in an application which has not been heard, and you use it as evidence in your application.
That's insufficient.
It's obliged.
Your honor, before I was rudely interrupted by the representative of the government of Uganda, I was going to draw your attention to, among others, in this very court, criminal miscellaneous application number 001/2025, in which the number 01/2025, in which the state made reliance to the affidavits of detective IP or Benedict, who saw that he's aware not only that their chosen were charged before the General Court Martial, but that he's also one of the people who are charged with investigating their matters. That is the date of custody or remand in accordance with the Constitution. Your honor, the plea for mandatory bail that my comrades have emphasized pursuant to Article 23, Clause 6, Paragraph C, is intended, among others, to ensure that the accused get a fair hearing. The only way people can effectively defend themselves who have spent 6 months on remand is when they have liberty to defend themselves from home, and also to ensure that their trial is and detention is not too lengthy. Your duty as this honorable court is partly adumbrated by Article 20 of the Constitution. Clause 1 of Article 20 of the Constitution reminds us that the right to liberty is inherent. It's not a gift of the state. Clause 2 of that article is the effect that this court and the office of the Director of Public Prosecution and other people should not only respect and uphold the right to liberty and other fundamental rights, but also promote them. What we do here this morning should be seen to promote the liberty of Besigye, Obied, and Dennis. It should not be seen as frustrate their liberty. And should the state get wayward and try to frustrate that liberty, it involves you as the judicial officer presiding over this matter under that article to rein in the state and to put and ensure that it's back on the track, the constitutional track of guaranteeing that liberty. These provisions of the Constitution are very important because the Constitution is supreme. The supremacy of the Constitution is underscored by Article 2, clauses 1, 2, and 3 of the Constitution. So any other speech, any other law that tends to negate the constitutional entitlement to liberty after 6 months should be seen as inconsequential to the extent of that. And I said this in anticipation of some speech that may come after here relating to some practice directions, which are in fact a challenge to the are being challenged before the Constitutional Court. But even those guidelines themselves acknowledge that the Constitution comes first. At this juncture, my young brother who wanted to give us an authority should give us, then our provision will come through.
Prosecutor. But it is unfortunate that he would refer to the previous incarceration of Aaron, whether in just knowing very well that it was before a lay court, because he said that he may once again be important. It is not a fair thing to do, and it cannot be taken expressing regret that my friend, my learned friend, would joke with liberty of our colleagues taken away illegally, as the Supreme Court found. But having said that, I want to commend my team. They have demonstrated to your honor the law on bail, and the fact that the court has no discretion whatsoever. But we also want to refer you to one more case from the Supreme Court in the Foundation for Human Rights Initiative versus the Attorney General and the Solicitor General, Constitutional Appeal number 3 of 2009. Yes. Karua CJ, Foundation for Human Rights Initiative versus the AG and SC. Constitutional Appeal number 3 of 2009. The decision is by Karua CJ, as it then was. He held that when an accused person applies for bail, the court retains the discretion whether or not to grant bail to the accused person, which discretion has to be exercised judicially. But now comes the most important. The only time when the court has no discretion is when a person has been on remand for the period stipulated in Article 23(6)(b) or 23(6)(c). In those situations, the court shall grant bail. I suppose the court retains the power to determine the terms of the bail. In other words, this is a Supreme Court decision, and this honorable court is obliged to follow not just the High Court, but the apex court decision. Now my 2 points. I want to refer you to the obvious, Article 126 of the Constitution of Uganda, which clearly states that judicial power is derived from the people and shall be exercised by the courts established under this Constitution in the name of the people and in conformity with law and with values, norms, and aspirations of the people. In other words, the framers of the Constitution and the people of Uganda put the trust in judiciary to advocate on this matter. I am therefore urging Your Honor, in exercising your judicial power and in giving the ruling in this bail application, to abide by the values of constitutionalism and the rule of law, and in the name of the people of Uganda, grant our client's bail. My learned friend will be submitting on the 3rd on A3, but they have a similar history of detention, not exactly the same period, but anybody who has finished more than 180 days, you are obliged to release them pending their committal. I'm also reminding the court the obvious that the scales of justice must balance, and in Article 21, equality and freedom from discrimination, we come before you as parties with equality of arms. Therefore, the prosecution and the defense are equal before you. None is superior. And none should come with the assumption that they carry more weight. Therefore, it is your duty to demonstrate, because justice must not only be done, but must be seen to be done, that the scales of justice are balancing, and that you are availing all the parties, and in this case, A1 to A3, the due protection of law. And the law on bail is for their protection. So we urge you to exercise your discretion to give them bail on such terms as you find fit, to enable these proceedings to continue when they are free, because they have stayed in custody for the maximum period allowed by law.
Your Worship, we were not aware of the affidavit that was filed in court. We were not aware of the affidavit which was filed by the applicants. I don't know where the courteousness went, because we have been serving each other. Prosecution has been making it point to serve the defense each and everything that has been filed. That said, it is imperative of your worship that you grant us 1 hour standover. We look through that affidavit and we make an informed response because we do not know what it contains. 1 hour to look through it because it seems to have a lot, and it will be just fair and just that the prosecution or the respondent looks at it. Also, we haven't been my colleagues have been submitting and have been keeping authorities to themselves. They are the people who are actually singing fairness, but they are acting obstruct. Every authority that has been talked about has not been given to prosecution. We feel that is very unfair in that regard because we believe they prepared for this application. The fact that they put in an affidavit in support, they were prepared, and therefore you are supposed to prepare all the authority and also grant us an opportunity to prepare our defense in this matter. There's an affidavit of Proscovia. We haven't. And this is what we are asking for, that court gives us 1 hour, only 1 hour, because we operate as a team, the way they do. So we need an hour to look at that affidavit and prepare our response. We're going to give it today, after an hour. And that is our prayer.
What we are opposed to an adjournment for 1 hour. If he was talking of 10 minutes, 15 minutes it would be okay. Because the only reference to that affidavit is to the date. A1 and A2 have been in custody 16 from the 20th of November 2024. The contents of the affidavit were not part of this application because it's an application for bail. So if you want to look at that paragraph, and I'm saying this because the court is aware that as senior counsel, I am coming from a neighboring country. I flew in today. I hope to go back later. We were in court last time. The prosecution opposed to us coming before the court the next morning. And then after I have left, brought the amended charges. If it's about fairness, let's treat each other fairly. The only thing mattering here is the date. The owner may give him 15 minutes to look at the affidavit. 1 hour is too much to ask.
Just to be on record.
Your Worship, before my colleague responds, the last time we were here, the court adjourned so that we make this application. The person who was present representing the state was Mr. Richard Kirivumbuka. So he's aware, because the court indicated we adjourned for your brother magistrate, because the presiding magistrate was not available, and it was made very clear that the application for mandatory bail would be made because the accused persons had spent more than 1 days. So that was the 21st. We told counsel. The other one about the authorities. All the authorities which are being cited are versus Uganda, whereby Mr. Billy Vumbuka, representing Uganda, is a party. So it means that by default, the office which sent him argues the cases. that they are not responsible to take stock of these authorities and armed counsel aware of what we are coming to do cannot be taken on to the accused persons. He was aware we were coming to argue against that, and that is why court will note that when my land calling Mr. Alvaro asked that we proceed with this application, he did not oppose because he was on notice. So his belated response perhaps is also courteous of counsel to agree when he's overwhelmed and concede that the circumstances are beyond him, so that court proceeds and pronounces itself on the conditions for mandatory bail. So we do not accept the 1 hour because my colleague was aware of what we are coming.
I take a notice that you have just submitted this. You have just sneaked it in. That may look so unfair to the rest of my senior colleagues that I can say I don't have any authority. For sure, you are not submitted. You are not giving me the authorities as required. But nonetheless, maybe court can take a decision on that and then we can guide us on what to do.
So since the prosecution says that it needs to look at the evidence, I'm going to give it strictly 10 minutes.
Since we never filed an affidavit in reply, I pray for leave of court to reply to the application. Your Worship, the applicants made an application under Article 23, 6C. Although my senior colleague in Panga was referring to section Article 25, it is you're on record for saying Article 25, but it is Article 26, 6C. You got moments and you see it.
I thank him for the correction.
No worries. Their argument is that the applicants have been on remand for over 6 months. And they are premising their argument on the charges under the General Court Martial. Where the first two applicants, that is retired Colonel Dr. Chiza Besigye and Haj Obed Rutare, appeared on the 20th of November 2024. The defense or the applicants are also relating the same to the charges that the applicants are facing before this honorable court. Article 23(6)(c), which is the basis of this application, is to the effect that where a person is arrested in respect of a criminal offense, and in the case of an offense triable only by the High Court. If that person has been remanded in custody for 180 days before the case is committed to the High Court, that person shall be released on bail on such terms as the court considers reasonable. This article is perfect. However, it doesn't apply in the instant case. Why? The applicants appeared before the General Court Martial. On charges which are triable not only by the High Court, but the lower court. That one collapses the application because the article is very clear. Only, let me repeat it, if that person has been remanded in custody, in a case of an offense triable only by the High Court. The charges the applicants were facing before the General Court Martial were not offenses or charges that fall under Article 23(6)(c) of the Constitution. In other words, it is only the charges which the applicants are facing before this honorable court that apply under Article 23(6)(c). This is a total misinterpretation of the Constitution by the defense. The applicants appeared in this court, which I may refer to as the civil justice system, on the 21st of February 2025. And this the legitimate charge which this honorable court has jurisdiction over on the 21st of February 2025. That said, even if the applicants were facing charges that are referred to under Article 23(6)(c) of the Constitution, the charges of the General Court Martial do not apply in this honorable court, because the court martial is under military justice system. And this court does not have powers on any matter that is before the General Court Martial. The same applies to DPP, the Director of Public Prosecutions, whom I represent today. So it would be irregular to bundle the two justice systems and hold the civil justice system liable for, actually responsible for what happened in or before the military justice system. As if that's not enough, the charges under the General Court Martial seized and were terminated by the constitutional ruling of the Supreme Court. In other words, DPP never inherited any charges which were instituted before the General Court Martial. DPP initiated or directed for fresh and new investigations, which are the basis of the charges that the applicants are facing. The applicants furnished this court with a copy of the charge sheet, which was before the General Court Martial, and I believe this court takes judicial notice of the charges on the charge sheet apparently before court, and if that is the case, court may realize that the charges do not speak to each other. The General Court Martial has different charges, there were different charges, and here the applicants are facing charges which are completely different. But even if the applicants were charged with offenses which attract death, even if the applicants were charged with offenses which attract death before the General Court Martial, the civil justice system where this honorable court falls does not have jurisdiction and does not enforce the UPDF Act under which the applicants were charged. So that makes the two completely different. Your Worship, the question is, does this court have a record of the General Court Martial? And if it is true that it does not have, the way I believe, then this court, where does this court get the moral and legal authority to be bound by proceedings which are not before it? We invite this court to agree with the prosecution that this court does not have any moral or legal authority to consider the record of proceeding in the General Court Martial, even if it had it, because this court was not party to that. This court did not in any way inherit the proceedings of the General Court Martial. And I beg also to question, ask again, and I also ask this court to ask itself, when did the charges against the applicants, when were they filed before this court? When did this court first interact or come into contact with the applicants as a civil justice court? It is simple mathematics. It is on the 21st of February 2025. And that translates, what does that mean? Lawyers are not good mathematicians, they do not count money, but I try to count. The applicants have been in custody for 3 months and 8 days.
Sorry, what's interrupted on me? What's interruption?
21st of February.
Sure.
So they have been, before, they have been on remand not more than 4 months, to put it that way, generally. Now, if that is the issue, if it is true, they have been on remand for not more than 6 months, are they entitled to the provisions under Article 23, Clause 6C? The answer, Your Worship, is in the negative. No. And if that is the issue, the other question is, wasn't this a misinterpretation of the provisions of that article by the defense? We invite this court to answer it in affirmative. Your Worship, we do appreciate the provisions of that article, and would have no problem court releasing the applicants if they had clocked the mandatory period. But they have not. This court would have assumed jurisdiction which is over and above that it has in the civil justice system. My brothers quoted several authorities in that regard. They quoted so many cases. It is a submission that prosecution agrees with the defense that this court is by law supposed to protect all the rights of the applicants before it. But court should not also have this matter handled on a matter of technicality, as it was submitted by my colleagues under Article 126(2)(e) of the Constitution. Even if the applicants, for example, if I'm to play a devil's advocate role, even if the applicants had clocked mandatory, prosecution duly noticed, put the defense, the applicants on notice that they are ready to commit the applicants. They are on notice. That mere notice ties up the hands of this court. It is our submission as prosecution that ties up this court. And any decision which is to the contrary would be administering substantive justice on a matter of technicality. How? Because the defense submitted that Article 23, Clause 6C applies instantly. and that court cannot do anything else for as long as the accused person or the applicant clocks mandatory period. Our argument is that even if they had clocked mandatory period, the mere fact that we put them on notice that our committee papers are ready, the provisions under Article 23, Clause 6C is not a ticket to have the applicants released on mandatory bail when the committee papers are available. Because the issue then is, what is the substantive justice here? The substantive justice here is to have an expeditious trial of the applicants, which can only be done after being committed to High Court. The argument by defense that, the first thing we have to do is to consider mandatory bail, let the applicants be released on mandatory bail, then the rest come later. That is the thinking selfishly. It is acting contrary to Article 126.6.2e, which they quoted.
Summarize your submissions.
Josh, they took a lot of time.
Yes, but
In fact, I'm just about 10% of the time they took. So it is a submission, Your Worship, that this court disregards and dismisses the application by defense on the basis that this court has no control over matters before General Court Martial. They have not clocked mandatory period of time. The fact that they were remanded on the 21st of February 2025. Because this application, Your Worship, is in bad faith. It is in bad faith, especially given that the committee papers are available. We are ready to commit. We have been on record several times, and we have submitted that defense has been arm-twisting prosecution. Today, the prosecution of this matter, by using all the tricks available, all tricks that are actually at their disposal to ensure that they frustrate the process. They should have been the people who should be agitating for an expeditious trial. But now they are speaking the other language. Because as prosecution, we believe that now that our committee papers are ready, it doesn't make sense to have the applicants released on a mandatory. It is our prayer that the accused persons or the applicants be committed and have the matter expeditiously tried, because we are ready. We invite this court to dismiss the application. We are tainted with that in this application. We so pray.
Issue of the 80 days has been tackled extensively by my colleagues. 180 days. I just wish to reiterate that Land Council for the State, Mr. Billy Vumbuka, conceded, or he said, that he would have no problem with them being released if the 180 days are met. In his view, the 180 days should start when the accused persons were brought before this court. Your Worship, my colleagues have cited authority to show that indeed the courts of law have found that the remand period where there has been a court-martial intervention start from the time of remand by the court-martial. On that basis, and was on his own concession, the accused persons should be entitled to be released. We take it that his submission and his concession was based on circumstances where he was not alive to that decision, but it clears him lest he's taken to have allowed to have them released. He said, I have no problem if they have clocked the mandatory period, but they have not, because he said it's the magistrate's court, but that decision has been cured by a higher court. The second one, my land friend, Mr. Billy Vumbuka, alleged that the DPP brought new charges. He did so in an attempt to nullify the custodial condition in which the accused persons are placed. Your Worship, under the Evidence Act, we are alive to the fact that court takes judicial notice of documents on the court record. Your Worship, in the criminal application number 1 of 2025, I am referring to the, my colleague is unhappy, but I'm referring to that notice of motion, which, Your Worship, was endorsed by the Chief Magistrate. So it was owned by the court. It is a court record.
But did I submit on it, the senior colleague?
With
Without due respect. Without due respect. Without due respect, senior, maybe yes.
I request that he listens to me.
Let him submit.
Yes. And if I may just, Your Worship, put the matter in proper perspective, the application was brought at the instance of the land chief state attorney, and he was pursuing this application with vigor. So he's alive to this application. It was an application to access, and he brought it up. Your Worship, that notice of motion, as it should be, is supported by an affidavit of DIP or Dick Benedict. I would want to refer to the first 4 paragraphs.
But Your Worship, I think this is irregular. I know court has jurisdiction to overrule prosecution. I know that, Your Worship. But again, as a prosecution, we cannot see when there's something wrong ongoing. First of all, we never responded anything in respect to that notice of motion in our response. I believe that my senior colleague should be making a rejoinder on specific issues which we raised in our response.
Yes,
that was not part of it. Secondly, he's raising other issues. He's now going into details of the affidavit, which was never part of our response.
Your Worship,
I respect my senior colleague. Do you understand? I do respect that, but it being senior is not a prerequisite to go into details which were never brought up at any point during the trial. We never talked about it.
Your Worship,
I pray that this court prevails over him to speak and submit and address court on other matters which arose in the reply.
Your Worship, if I may, I am responding to the contention of the DPP having brought new charges.
Okay, so you restrict yourself.
Absolutely.
Don't go into
Yes.
details.
And I'm mindful of the fact that, again, the affidavit my colleague is objecting to wantonly was drawn by the DPP. It states as follows, my Lord, Your Worship, in paragraph 2.
Councilman, please don't go there.
Yes, I'm just referring to my Lord. It says that the respondents are accused persons in Nakara Criminal Court number 8 of 2025, which is the matter before you. The respondents were previously charged before the General Court Martial at Machindye and were being tried there. However, following the decision of the Supreme Court in Constitutional Appeal number 2 of 2021, Attorney General versus Michael Kabaziguruka, the case was transferred to the Uganda Police. The Uganda Police took over investigations of the case on 11th Feb, and I was one of the officers who was assigned to investigate the case. The case was transferred. It is in the affidavit. Your Worship, when you transfer, let's be practical. Your Worship, if you transferred your car to me, I inherit it.
God forbid.
So there are no fresh charges. As a matter of fact, and my land friend referred to the Supreme Court decision. the Supreme Court decision actually directed that the files be transferred. It did not direct that those charges be dropped and fresh charges brought. So it is coming as a transfer. It means that the process is continuous. He cannot allege that these are new charges. The transfer, incidentally, and I reckon my colleague knows, is a simple English word, not a legal one. The matter acquires a new conductor. We had the conductor in the General Court Martial. Now we have the conductor, fortunately or unfortunately, who is Mr. Birivu. It was a transfer.
Under which dictionary?
The other one, indeed. Your Worship, in trying to disparage that article, he said it's not applicable because of the charges. One of the charges against the accused persons in the General Court Martial is the offense of treachery, which under section 129 of the UPDF Act, the penalty is death. Applying it, I don't know the Latin word there should be mutatis mutandis, but transferring it means that it is an offense because of the penalty, which cannot be tried by a magistrate court. It can only be tried by the High Court. And Your Worship, it should be remembered that before the decision of the Supreme Court, the General Court Martial insisted that it was equivalent to the High Court, i.e., it was the High Court of military law, only that now it was charging civilians. It is therefore a lame argument for my colleague to contend that because it says High Court only, and referring to that section 9, this court is bound not to be mechanical in approach. If an offense in any other court has a penalty of death, it means that if it is transferred to the civilian dispensation, it can only go to the High Court. It therefore becomes an offense which can only be tried by the High Court in its original jurisdiction. As I wind up, Your Worship, my Lord, Your Worship, Mr. Birivu tried to convince you not to refer to what we had said because the record of the GCM was not here. But in his opening remarks, he said that the accused persons were arrested in November and arraigned in the GCM. He did not furnish a copy of the record to support his allegation. So I don't know whether his submission is gathered from the sky or whether it should only be taken when he's submitting. It is not denied, and my worship, it is in the affidavit which he responded to. In paragraph 3, the affidavit of Procodia Kunihira, which hasn't challenged, that in fact they were taken captive on the 16th of October and produced in paragraph 4 in the GCM on the 20th of November. Applying the decision of Mr. Justice Mwata, the period of remand then starts to run from the 20th of November 2024. Your Worship, again, my colleague referred to Article 26.3 not being applicable on the premise that the committal papers were ready. The plain reading of Article 23.6 says before committal. It doesn't say before availability of committal papers. So again, my colleague Mr. Birivu knowingly is trying to read into the Constitution things, not even they are not things which don't exist. The clause is very specific, and incidentally, the release of the accused persons on mandatory bail does not stop the committal, because they can be committed while they are on mandatory bail. So there would be nothing to stop this court from releasing them on mandatory bail, as they are now entitled to, and then they return to court by its directions for committal. And Your Worship, that can be one of the conditions. We release you today, return tomorrow for committal. It is within your power. It is not within the wishes of Mr. Billy Vumbuka or the state for that matter. Your Worship, I conclude, because sister and brother magistrates have declined to grant this order. They have shied away on the basis of matters being of a capital nature. Others have shied away on the basis of fear of what will happen if accused persons rightly entitled to mandatory bail are released. Your Worship, decisions of this nature in these times can be challenging, but that is why we are in a court of law. It is the reason why disputes, however egregious, however grave, however serious, are brought to a court of law which is independent and which is free from influence and free from fear. Your Worship, we cite in the journal, The Discipline of Law, by Lord Denning. Your Worship, states this, I'll just read it. Just to comfort the court that despite the circumstances, it is bound to exercise its duty. That if the powerful still abuse their powers without restraint, it is thanks to the dominant influence of timorous souls. Timorous souls, Your Worship, speaking to judicial officers or courts who shy away, exercise the power granted to them by the Constitution because of fear. All spirits will not let such abuse stand. Any rule of law which impairs the doing of justice, they will do all they can legitimately do to avoid that rule. They will even change it so that justice before them is done. We therefore appeal to this court. The Constitution commands the court to release the accused persons on mandatory bail because they have met the standard, subject to the conditions which the court fixes. That circumstances are dire and perhaps strange things will happen, that is an after event. The role of the state, the role of the state, as I conclude, Your Worship, was very simple. Under section 76, the duty of the state, Mr. Bilbuka, my brother, was to demonstrate two things. They are entitled to be released unless, before the expiration of that period, they have been committed. In this case, there is no committal and he has conceded. He has his papers ready, perhaps in his court, but has not done the committal. Two, the magistrate is satisfied that it is expedient for the prosecution, for the protection of the public, that the accused persons should not be released from custody. He has not demonstrated anywhere that these are a danger to the public. He has not therefore discharged his burden in any way, despite the time court accorded him. In any event, your brother magistrate allowed the public to interact with the accused persons and they were not endangered. To the extent that Mr. Bilbuka has not done anything to dispel or to prove this duty, it is our prayer that the inevitable must happen, that the accused persons are released on mandatory bail, subject to the conditions which the court shall fix.
Recommendation made by the defense for the release of the accused persons on mandatory bail as provided for under Article 23(6) of the Constitution on the basis that the accused persons have clocked the 180 days spent on remand before committal. The defense has made detailed submissions that Article 23(6) is a command of the Constitution and that this court does not have the discretion but rather sets the terms for the bail. The prosecution in reply submitted that the charges the accused were charged with under the court-martial ceased and were terminated by the constitutional decision of the Supreme Court. The prosecution submitted that the accused have spent 3 months on remand and not 180 days. The defense in rejoinder submitted that the proceedings of this court are a continuation of the proceedings of the court-martial and thus the days spent on remand should be considered from the time the accused first appeared in the court-martial. The defense has provided a number of authorities to buttress its submissions for grant of mandatory bail under Article 23(6) of the Constitution. This court is mindful of the provisions of the Constitution of Article 23(6). However, this court also takes cognizance of the Constitution Bail Guidelines for Courts of Judicature 2022, which commenced on 28th June 2022. The charges the accused are charged with are capital in nature. Practice Direction number 10.3 of the guidelines provides that for avoidance of doubt, mandatory release on bail for offences triable by the High Court of the Constitution under Article 23(6) of the Constitution shall be granted only by the High Court. This provision asks the jurisdiction of this court to grant the applicants mandatory bail. The fact that this court's jurisdiction is ousted by the Practice Direction number 10.3, this court cannot go ahead to determine whether the days on remand cover the period before the accused were arraigned before this court. I wish to also add that all the authorities cited by the defense are authorities of the High Court, which granted mandatory bail in capital offences, which is well within its jurisdiction as per the bail guidelines. For the above reasons, this court lacks the jurisdiction to grant the applicant's application for mandatory bail. The applicants can apply to the High Court for mandatory bail.
Your Worship, yes, a minute. Let me make. Yes, Your Worship, as prosecution, Your Worship, now that this court has pronounced itself on that application, we intend to make an application to amend.
Your Honor,
Can I submit?
I'm intervening.
Let me hear what he has to say first. Let me hear.
Your Honor, thank you very much. We have had the ruling and we respect it. And in immediate response, Your Honor, before even the state can come in, the guidance you have cited, the immediate you cited guidance 10, guidance 11 says that once you do that, then 11.3 says that you immediately transfer the file to the High Court, and it is our prayer that they are eligible for mandatory bail.
Your Worship, joining the issue, again citing those guidelines, because those guidelines, just to put it, to create a link, provide that an application for mandatory bail in a court of this nature will be oral. We have made the oral application. The court has found, as it did, that it does not have jurisdiction. It has not found that the accused persons do not qualify, meaning that the matter now, the issue, is about jurisdiction. Therefore, and relying on the same regulation or guideline 3 reads, a magistrate court shall submit to the High Court files of persons eligible for mandatory bail, and upon receipt, the registrar shall cause the files to be registered in the bail register. To that extent, and guided by the first sub-regulation, which provides that applications in the magistrate are oral, ours is an oral application now, given the finding of court, for the file to be forwarded to the High Court, which is a command to the registrar to enter it in the bail register so that that application is considered. It appears to be mandatory and not discretionary, so we reckon that once it is being referred to the court, it is bound to abide. I reckon that the response from Mr. Besigye will be to affirm the mandatory command so that going forward, the file proceeds to the High Court. Most obliged.
Your Worship, in reply, again, this is a total misinterpretation of the provisions that my and colleagues are relying on. One, for a magistrate to refer a matter to High Court in case of mandatory bail, that court must have pronounced itself on the fact that the applicant or the accused person has clocked mandatory period in custody, which is not the case in this regard. It is not a duty of this court to pave way for the release of the applicants. The applicant has a fleet of senior lawyers who can move High Court in this regard. There is no basis for this court to refer this matter to the High Court because the applicants have not clocked mandatory period in custody. You cannot have a matter in February and then in May you're saying the applicant has clocked mandatory. It is simple mathematics. This court has no jurisdiction. In other words, that application is misplaced. If the applicants wish to make an application before High Court, they can do it on their own initiative, not through the vehicle of court. That court should move them. And it's not, by the way, it's not the fault of you, Your Worship, that the application which my brother Bayan has been submitting upon has not been fixed. And therefore, I don't want to use a harsh word. I want to use it. But
Summarize.
it would be, but you have been giving them a lot of time. When it comes to me, you give me 1 minute. His application is misplaced. His request is misplaced. His request is misplaced. They know where to go in case they want the application to be fixed. In summary, Your Worship, I pray that you dismiss that application and we proceed. We proceed with the amendment of the charge sheet and other processes for today, as prosecutor shall actually address court. We so pray.
We have cited the guidelines. We cited the requirement of the court to submit the file. Unlike my colleague, Mr. Besigye, court did not say that the 180 days period has not been met. But Your Worship, touching from 3, where a magistrate shall submit to the High Court files of persons eligible for mandatory bail, and upon receipt of the register shall cause the files to be registered in the bail register. 4 says the register shall list the files submitted under subparagraph 3 for hearing by a judge. 5, which is very important, says upon disposal of the bail application, whether it may be granted or it may not be, the file shall then be returned to the magistrate's court to enable the court to proceed with the committal. It means that once we've applied for bail and the court has found as it has, that's a matter to the High Court. Once we have applied, in fact, Regulation 3 doesn't require that we apply, it requires that the court forwards the file. It means that because it is a right of the accused, all other proceedings stop until the matter of mandatory bail is handled. So again, the words in that regulation do not say may. It is shall. As lawyers and advocates who appear at the bar, we are enjoined to be officers of court. We are praying, Your Worship, that you do not allow Mr. Billy Vumbuka to mislead court and yourself. So, we are therefore saying that the command is that the file be forwarded. We also refer to the same regulations, which is Regulation 10, Sub-Rule 2. A person who has been on remand, which my colleague referred to, for more than 100 days, the magistrate shall immediately refer the file. Mr. Bill Gumbuka will have his day in court to make all the healthy submissions. We are saying that this court, its ruling, now does not have any matter to deal with this one. Let us go. We shall return when that matter is. And perhaps to add, we are certain that when we go away for a bit, it will allow this court some respite. So we pray that we go to the High Court to determine that right which cannot be abrogated from. Then we shall come back when the court has pronounced itself in that regard.
Decision on the application for mandatory bail. Court having ruled that it cannot grant the application for mandatory bail, the defense has submitted that this court should, as per the guidelines, submit a file to High Court for the application for mandatory bail. This court has not pronounced itself on whether the accused persons have clocked the period on mandatory bail. And as such, this court cannot cause the file to be forwarded to High Court as provided for under guideline number 11. Considering that prosecution intends to amend the charges and make other proceedings thereto, prosecution should proceed with the application for amendment to the charge sheet.
Most obliged, Your Worship.
Because the decision to continue after our application has been rejected is not subject to the revision, it is not proper for the court to continue the trial. Our position is strengthened by the Supreme Court decision of Charles Onyango and Andrew Mwenda versus the Attorney General. Mulenga J. SC, as he then was.
Just keep it short.
Yes. The import of this decision is that when a process in the lower court is under challenge in the higher court, the lower court must wait lest it proceeds and this decision or procedure is found to be faulty to the prejudice of the accused person. So our request, therefore, because we have sought a revision under the Criminal Procedure Code, we are referring 848. We are asking the court to review the file, including the decision regarding bail, the mandatory bail.
You're requesting?
Yes.
You request the court?
Yes. But we are going to apply for a revision. We apply for a revision. So we shall be requesting the court, the higher court, to review the proceedings in this court, to satisfy itself as to the correctness, the legality, and propriety of its finding. So to the extent that we are testing court regarding the legality, the propriety, and the correctness of your finding, we beseech you to stop so that the file goes and checks the correctness of what we are doing. Your Worship, because we are told that we are submitting decisions of the High Court, in the application, criminal application number 1 of 2025, the very one we are referring to, Uganda versus Karua Besigye and others, that is what happened. When the court made a decision regarding the cross-examination of the deponent, whether it be in public or in a closed court, you allow, most humbly, Your Worship, to submit your proceedings to a higher court for correction. It is the request of the accused persons. We think it is their right, and we should allow Your Worship to submit your proceedings to the High Court, as indeed